Hello, everyone. Thank you for joining today's presentation. I'm Christina Shaynak-Diaz. I'm a private attorney specializing in behavioral health law, confidentiality, and public agency compliance. Today's topic is the sharing of confidential health information between Ohio's behavioral health and criminal justice systems. For today's presentation, we're going to start off with an overview of the federal and state confidentiality laws. We're going to address the disclosures that healthcare providers are permitted to make to those in the criminal justice system under those laws. And we're going to talk generally about recommendations and considerations for the sharing of information between the two systems. So starting off with the confidentiality laws. The federal and state confidentiality laws that apply to persons receiving services in Ohio's public behavioral health system are the Health Insurance Portability and Accountability Act, HIPAA, and specifically HIPAA's privacy rule. There's also the Federal Confidentiality of Substance Use Disorder Patient Records Regulations, more commonly referred to as 42 CFR Part 2 or just Part 2. That's a bit of a lesser known law than HIPAA, but it has been around a lot longer than HIPAA. And we're also going to talk about the state confidentiality laws that can be found in the Ohio MOS statute and rules. So let's start off with HIPAA. We're going to talk first about who is required to comply with HIPAA, and then we'll talk about the information it covers. So HIPAA covered entities include healthcare providers and health plans. It's important to note that not all healthcare providers are HIPAA covered entities. HIPAA specifically says that it's those providers that conduct certain transactions in an electronic format. So those that do billing in an electronic format, or those that do inquiries or pre-authorizations in an electronic format. Those purely paper-based providers would not be considered a HIPAA-covered entity by the definition used in HIPAA. But for those healthcare providers that do conduct standard transactions in electronic format, they are a covered entity regardless of whether they are a provider of physical health services, mental health services, addiction services. They're all considered to be covered entities under HIPAA. The other type of HIPAA covered entity is called a health plan under HIPAA, and that can be your private insurance companies such as Anthem and United. It could also be public benefit payers such as ADAM boards and the Ohio Department of Mental Health and Addiction Services. So I want to also be clear who is not a HIPAA covered entity. I often get questions about if a person has mental health information or physical health information that is a staff person at a court. Is that information protected by HIPAA? I even hear HIPAA referred to in the context of sharing information with families or friends. It's important to note that only those healthcare providers and health plans that we talked about on the last slide are HIPAA covered entities. Law enforcement is not a HIPAA covered entity. Court staff, schools, family members and friends are not HIPAA covered entities. They have no requirement around your personal health information. Jails are sometimes HIPAA covered entities, or at least certain staff within jails are HIPAA covered entities. And we're going to talk more about that a little bit later on. So in general, HIPAA covered entities are those that provide and pay for healthcare services. If an organization or a person does not engage in those activities, they are not a HIPAA covered entity. So now that we know who is covered by HIPAA, let's talk about what information is protected under HIPAA. The information that HIPAA protects is referred to as protected health information, or PHI. And essentially, it's information that relates to the person's physical or mental health or other condition. It's created or received or exchanged by a HIPAA-covered entity in the provision of healthcare or payment for healthcare services. And it identifies the individual directly, or it can be used to identify the individual. If all three of these criteria are met, the information is considered to be PHI and it's protected by HIPAA. This is a pretty broad definition, so pretty much any person-specific information obtained about a person in the course of providing covered entity services, which would be the provision of care or payment for that care, is protected information. And keep in mind that goes beyond name, addresses, dates of service. It frankly involves about 18 different specified identifiers. So if you wanted to de-identify protected health information to make it not protected health information protected by HIPAA, you would have to either remove 18 specific identifiers that are listed in the statute, or there's a process by which you can have a statistician determine that the information that will be used is not identifiable, that essentially it cannot be used to identify the person. And I wanted to point this out and the process required under HIPAA for de-identification, because I often hear people say, you know, if you strip out name or if you strip out diagnosis, dates of service, the information is de-identified. So I wanted to make it clear that in terms of HIPAA, once you truly de-identify protected health information, it pretty much just leaves aggregate information that could be valuable for reporting or statistical purposes, but it's not really a way to exchange information with other systems about a specific person, even if names are removed. So that was our high level who's covered and what's covered by HIPAA. I wanted to move on to who is covered and what is covered by the confidentiality of substance use disorder patient records regulations. And I typically just refer to those as 42 CFR Part 2 or even just Part 2. Also important to note is about 2 years ago, they changed the title of these regulations. It was confidentiality of drug and alcohol disorder patient records. It is now confidentiality of substance use disorder patient records. As I mentioned in the introductory slide, 42 CFR Part 2 is less known than HIPAA by most people. Most people are not aware that there is another federal confidentiality law related to provision of health services, except for those in the behavioral health system. So it's especially important when we are talking about exchanging information with those outside of the behavioral health system, that they understand there is another factor, another consideration in addition to HIPAA when it comes to the disclosure of information. And as we will see, 42 CFR Part 2 is much stricter than HIPAA in terms of what it permits to be disclosed. So in terms of who is required to comply with Part 2's disclosure requirements, it is much broader in terms of who is required to comply, who is required to keep information confidential. Most substance use disorder treatment programs are Part 2 covered programs. And in addition to the disclosure requirements, they have administrative requirements and other things that Part 2 requires them to comply with. And I won't go into a definition for the purposes of this training as to what an SUD treatment program or provider is. They know who they are at this point, and they can share with others if Part 2 applies to them and disclosures of information. Whereas HIPAA only had those healthcare plans and healthcare providers as covered entities, Part 2 reaches further than just SUD treatment programs. It has a term that was just put into law a couple of years ago called lawful holders. And this refers to recipients of Part 2 protected information. So if a substance use disorder treatment program discloses information to another person or another organization, that person becomes a lawful holder of Part 2 information. So lawful holders of Part 2 protected information can be a physical health provider that receives information from a Part 2 program, a hospital emergency room that receives that information, an entity that performs audit or evaluations, even a payer could become a lawful holder of Part 2 protected information when they receive that information from a Part 2 program. And Part 2 took this concept even further down the line and says persons or entities that receive Part 2 protected information from a lawful holder of Part 2 information also must comply with Part 2's disclosure requirements. So this pretty much means, under this rather new concept, that any person or organization that has information, that has received information from a Part 2 program, is required to continue protecting it under federal law. And that would be a surprise to a lot of people that do not work in the behavioral health field and receive this information, either pursuant to a person's authorization or under one of the permitted disclosures. So Part 2 in general requires that when Part 2 protected information is disclosed by a program, there's a statement that accompanies that information, which informs the recipient that it is protected by Part 2 and must continue to be protected by Part 2. In terms of the information that is protected by Part 2, it is information that is created or obtained by a Part 2 program in the provision of services or from another Part 2 program for the purpose of substance use disorder treatment, making a diagnosis for treatment or referral for treatment, and it identifies that person as an SUD services recipient or as having an SUD. So whereas HIPAA protects any information obtained by a covered entity that identifies an individual, Part 2 only protects information that specifically identifies the person as receiving substance use disorder services or as having a substance use disorder. It doesn't protect necessarily other personal information or even other health information unless that information somehow identifies them as receiving substance use disorder services. So whereas there were 18 identifiers that are considered to be protected health information under HIPAA, under Part 2, the protected health information in and of itself is simply diagnosis, substance use disorder diagnosis, a program from which services are received, or if they're a substance use disorder only program. So it has to be something that has that SUD specific information tied to it in order to be protected by Part 2. And keep in mind that most Part 2 programs are also covered by HIPAA. So whereas Part 2 protected information is much more narrow, HIPAA would require those Part 2 providers to protect the rest of the person's records and information. So another thing that's also important to point out is that Part 2 states that this information becomes protected at the point the person seeks, applies for, or inquires directly about services. So even if they make an appointment with a provider and they don't show for that appointment, the fact that they sought substance use disorder services is protected. So as soon as they have that direct contact with a substance use disorder provider, their identifying information protects them under Part 2. So as I did with HIPAA, what is not Part 2 information? The converse of what I just said is information that does not identify a person as receiving addiction services or as having a substance use problem is not protected by Part 2, even if it's information drawn from the person's records or charts. Again, to hit this point home, it has to identify that SUD piece specifically in order to be protected by Part 2. And we're going to talk a little later when we get to permitted disclosures under these laws about why this point is very important. And I hit it home a few times before we get there. Something else that is not Part 2 protected information, this is explicitly in Part 2, disclosing that a person was a no-show for an appointment that was arranged by a third party is not Part 2 protected information if that provider had no prior contact with the person. So on the last slide, when I said that information becomes protected at the point the person seeks, applies for, or inquires directly about services, that's because they have sought those services themselves. If a third party is making that appointment and the person is a no-show, they haven't sought services themselves, and the provider can go ahead and tell that referring agency that they had not shown up for services. If the person does show up for services, they are now a recipient of SUD services, and the Part 2 program can no longer share anything with the referring agency, including whether or not that person showed or not. And why that is important is when we talk a little bit later about the disclosures that are permitted to be made under Part 2, they are very narrow and very limited. So it can be very helpful when we're talking about sharing information between systems to have that referring party, that third party, maybe from a court or a jail linkage person, make the appointment with the substance use disorder provider on behalf of the person. Because if the person does not show for services, that provider can go ahead and disclose to the referring agency that the person was a no-show, and then the referring agency can go ahead and reach out to the person again and try to facilitate connection to services. So that was the who and what of the federal confidentiality laws. I also want to briefly mention Ohio's behavioral health confidentiality law. These laws are in the behavioral health system are found in Ohio OACBHA's statute. And in a nutshell, it says that records and information about persons receiving community mental health services that's held by providers, boards, and hospitals are confidential under the Ohio OACBHA statute. And it's pretty much the same with addiction records. Those receiving addiction or substance use disorder services in Ohio's behavioral health system, the statute protects the records and information about persons receiving community addiction services. The general rule that applies to with each of these confidentiality laws is that persons or organizations that are covered by them, that are required to comply and keep information confidential, must obtain a person's written authorization to disclose protected information unless the applicable law contains an exception that would apply to the disclosure. So knowing that as a general rule, if you have HIPAA protected information, Part 2 protected information, information protected under OMAS's statute, what you next need to turn to is whether the law contains an exception that would go ahead and let you make a disclosure without having to obtain the person's written authorization to do so. So in this next section, we're going to talk about what HIPAA permits in terms of disclosures to the criminal justice system, Part 2 permitted disclosures to the criminal justice system, and those that are permitted to be made under the Ohio OMAS statute. So starting with the exceptions to the general rule that HIPAA contains, stating that a person's authorization is required to disclose their information, I have narrowed the list of HIPAA permitted disclosures to those that apply to, or to those that would be utilized to make a disclosure to the criminal justice system. So for example, HIPAA has probably 2 or 3 times as many permitted disclosures as you see on this slide. But for the purposes of this discussion, I took out those that typically would not apply to disclosures made between the behavioral health and criminal justice system and just listed the most relevant ones here. So I'm going to talk about some of these more specifically than others. A few of them are self-explanatory, but I will read the list before we dig a little deeper. So HIPAA permits disclosures to be made for treatment purposes, when state or federal law requires a disclosure, for reporting of child abuse and neglect of certain other victims, for law enforcement purposes, as a part of judicial and administrative proceedings, when necessary to reduce or prevent a serious threat to public health and safety. And there's a specific category of disclosures that can be made to correctional institutions and in other law enforcement custodial situations. What's important to note is that there are specific requirements related to each of these categories of disclosures. So just because you see something on this list that matches the purpose of the disclosure you are looking to make, you will always need to go back to the regulations to make sure there aren't certain parameters or further restrictions around these disclosures. For example, when we get to reducing or preventing a serious threat to public health, there are certain persons that information can be disclosed to, and of course the threshold for what is a serious threat to health and safety. So always keep in mind to go back and look at any specific requirements that relate to a disclosure. So looking at some of these a little more closely to have a better understanding of what they permit to be disclosed, let's start with treatment purposes. So HIPAA states that a disclosure can be made by a healthcare provider for its own treatment activities or the treatment activities of another healthcare provider, even if that other healthcare provider is not a HIPAA covered entity. HIPAA also says that other covered entities can make disclosures for a healthcare provider's treatment activities. So an example of that would be if an ADAM board discloses client PHI to a contract provider for the purpose of coordinating treatment for that client. So an ADAM board is a HIPAA covered entity, and even though they do not engage in the provision of treatment, they can make a disclosure of PHI for the treatment activities of one of their contract behavioral health providers. In terms of treatment-related disclosures, HIPAA contains a specific definition of treatment, and it's rather broad. It talks about the coordination or management of healthcare and related services, consultation or referral between healthcare providers, and HIPAA also states that the minimum necessary requirement does not apply to disclosures made for treatment purposes. Most other disclosures that HIPAA permits states that you can only disclose the minimum amount of information necessary to meet the purpose of the disclosure. But HHS has made it very clear, both through the language of the privacy rule and also in their guidance and commentary, that they did not intend HIPAA to limit information to be disclosed for treatment purposes, for providers, healthcare providers' treatment purposes. They said that they want that exchange to be open if it falls within the definition of treatment, and that HIPAA is not intended to hinder those types of disclosures in any way. Another permissible disclosure that was on that laundry list I provided is the as required by law disclosure. So it's important to note that HIPAA never requires a disclosure to be made. It lists when disclosures are permitted to be made. So this disclosure states that if another federal law or a state law contains a mandate compelling a use or disclosure of protected health information, then HIPAA permits that disclosure to be made. It doesn't override that mandate for disclosure of information. So if something is permitted to be disclosed under Ohio law, say for example, under Ohio's felony reporting law, where any person must report information pertaining to the commission of a felony, even if that information would contain protected health information, because that disclosure is required under Ohio law, HIPAA says it permits that disclosure to go ahead and be made. And examples of required by law are those statutes and regulations that require the production of information, court orders and court-ordered warrants, subpoenas or summons that are issued by a court, and certain types of investigative demands. Reports of child abuse and neglect and abuse and neglect of certain other victims are also permitted to be made without authorization under HIPAA. I'm not going to go into detail about these, but keep in mind that whatever is authorized or required to be reported under state law is permitted to be disclosed under HIPAA. Another category of permissible HIPAA disclosures without authorization are disclosures for law enforcement purposes. And this purpose has a bit of a laundry list itself on these next two slides. So disclosures that healthcare entities, covered entities under HIPAA can make to law enforcement include those that are required by law, such as the felony reporting law I just talked about, when information is required to be disclosed to law enforcement pursuant to a court order or court-ordered warrant, pursuant to an administrative subpoena or summons. And then there are some broader categories. So disclosures can be made by a HIPAA-covered entity to law enforcement for the identification or location of a suspect, a fugitive, a material witness, or a missing person. And as I mentioned earlier, HIPAA has these categories, but then often limits what can be disclosed under that category. So in the case of identification or location of someone that law enforcement is searching for, treatment information other than date and time of treatment or discharge cannot be disclosed to law enforcement. It has to be kept to information that would facilitate law enforcement's finding of the person, and discussing treatment or disclosing treatment information would not be beneficial in that regard. So it's not permitted to be disclosed for those purposes. Information that pertains to crimes that occurred on the premises of the provider can be disclosed to law enforcement if it's pertinent to the crime that occurred. Healthcare providers and plans can also provide information about crime victims in certain instances. And when emergency healthcare is being provided, that information can be reported to law enforcement if the emergency health care is related to a crime that occurred, and law enforcement might need to know the location of the victims or the perpetrator, or where the person name and where they can be found needs to be disclosed. So we have quite a laundry list of reasons for which information can be disclosed to law enforcement. In regard to court-related proceedings, HIPAA states that a court order can authorize disclosure, require disclosure of HIPAA-protected information. The disclosure to be made must be limited to the information expressly authorized by the court order, but other than that, HIPAA allows court order disclosures to be made. When it comes to a subpoena or a discovery request that is not accompanied by a court order, so for example, it comes from an attorney for a client in a civil case, there are a few additional steps in making sure the disclosure can lawfully be made. Either a client authorization is needed to be responsive to a subpoena, or the either requesting party or the provider can obtain written assurances from the party seeking the information that either the client has been notified of the request and has not objected, or there's a qualified protected order around the proceedings. So getting the written assurances can be initiated by the healthcare provider, but either the healthcare provider or the requesting party, such as the attorney issuing the subpoena, can go ahead and notify the client of the request for information and give them the opportunity to object, or they can go ahead and seek that qualified protective order. The bottom line is that even when a healthcare provider receives a subpoena, if it's not a court-issued subpoena, either that client authorization is needed or those additional assurances must be secured in order to be responsive to the subpoena. Another category of disclosure that HIPAA permits are disclosures that are necessary to prevent or lessen a serious and imminent threat to the health or safety of the person themselves, to other persons, or the public. If that disclosure is going to be made to a person or persons or a professional reasonably able to prevent or lessen the threat. So an example would be law enforcement, or perhaps it can be, in the case of a minor, disclosure to a parent if they're reasonably able to prevent or lessen the threat. So it can be law enforcement, but it could be others as well if in the professional judgment of the healthcare provider, that person they're disclosing the information to is reasonably able to prevent or lessen the threat. Another category of disclosure to reduce or prevent threats are disclosures to law enforcement to assist them in identifying or apprehending a person that has either escaped from custody or that has made statements about participation in a violent crime. And then lastly, in that laundry list of HIPAA permitted disclosures that are applicable to the criminal justice system, there is a list of disclosures that can be made to correctional institutions, to prisons and jails and other custodial situations. So a provider or any HIPAA covered entity is permitted to disclose to a prison or a jail information about a person in their custody if that information is needed for the provision of health care to the person, for the health and safety of that person, other inmates, officers or employees, guests, whomever else at the facility, for the health and safety of persons responsible for the transporting or transferring of inmates. If they need to know certain information in order to effectuate a safe transport, that information can be disclosed. And then there's this kind of broad category of for the administration and maintenance of the facility. So essentially the management of the prison or the jail. There's no definition of that term in HIPAA, but to me that would include when special accommodations need to be made to an inmate because of their healthcare condition, maybe the need for recurring medication management appointments, information that the facility would need to know to factor in to disciplinary decisions or the use of isolation, things of that nature would fall into that last bullet point. So these last few slides have went over disclosures that can be made by HIPAA covered entities to other persons without the authorization of the individual. One last piece to keep in mind is that HIPAA does also have that minimum necessary requirement that I had mentioned in regard to treatment purposes. And that overarching requirement states that any disclosures of information must be limited to only what's necessary to fulfill the purpose of the disclosure. And as I mentioned earlier, there are some, very few, but some exceptions to the minimum necessary requirement. And one of those are treatment-related disclosures. So as I had mentioned, when it comes to disclosures related to treatment of the person or to coordinate treatment, there is no minimum necessary requirement around those types of disclosures. And I've also included a little bit of humor on this slide for you. I thought this comic was very appropriate to the concept of a minimum necessary requirement. So the last thing to keep in mind about disclosures of HIPAA protected information before we move on to part 2 disclosures is the redisclosure of HIPAA protected information. And I'm pointing this out now because it's a very different requirement under part 2. When it comes to somebody receiving HIPAA protected information, unless they are also a HIPAA covered entity or contractually bound not to redisclose the information, or another confidentiality law applies, there's no prohibition on redisclosure. So if, for example, a HIPAA covered provider discloses protected health information to a police officer, that police officer is not a HIPAA covered entity, is not contractually bound not to redisclose the information, and another confidentiality law does not apply to that information. So they can go ahead and redisclose that information. And as I mentioned, it's a different outcome with part 2. So I wanted to make clear what the rule is under HIPAA. So moving on to 42 CFR Part 2 and disclosures that it permits that are pertinent to the criminal justice system. As you will see on this next slide, the list is much shorter. And frankly, Part 2 permitted disclosures that don't pertain to the criminal justice system don't go much beyond what you see on this screen. So whereas when I talked about information protected under each federal law, HIPAA was much more protective of the information itself. Remember those 18 specific identifiers, whereas Part 2 was only protective of the information that specifically identifies as an SUD recipient or is having an SUD disorder. Things kind of flip-flop when we look at permitted disclosures. HIPAA has quite a reasonable list of permitted disclosures that can be made without obtaining the person's authorization, as we just walked through. But Part 2, if information is protected by Part 2, that SUD identifying information, there are very few disclosures that can be made without first obtaining the person's written authorization. So we are going to look at each of these in turn, starting with reporting crimes. So Part 2 permits disclosures to law enforcement just like HIPAA does, but it's much more narrow, whereas reports to law enforcement of protected health information under HIPAA covered, I think, 2 slides for different purposes, locating a fugitive from justice, a missing person, pursuant to an arrest warrant. We don't have that under 42 CFR Part 2. When it comes to information that identifies a person as an SUD recipient, a Part 2 program or a lawful holder of Part 2 information can only disclose information to law enforcement regarding crimes that occurred on the premises of the program or against program personnel. So for example, if a client of SUD services walks out of the facility and smashes the front window of the building, that program, for the purposes of reporting the crime, can disclose that the person was receiving SUD services there from the Part 2 program, and then additional information related to the crime, identifying information, location information, but beyond the who and what and the fact that they were receiving those services, it's got to be limited information that pertains to the circumstances of the crime. And also against program personnel. So say, for example, a person is at an off-site AA meeting, and after the AA meeting, they assault somebody who is at the group that is employed by the Part 2 program where the person receives services. Because it was against program personnel, even though it was not on program premises, that report with limited information can be made to law enforcement. Another permitted disclosure under Part 2 is disclosures for medical emergencies. If the disclosure is made to medical personnel who have a need for the information in order to treat a person who is experiencing an immediate threat to their health or safety, and immediate medical intervention is necessary. So it's a much higher bar in terms of it must be a medical issue that requires immediate intervention, and the information to be disclosed is needed by medical personnel. I have been asked before if law enforcement providing Narcan could be included in this category. So say, for example, a person is experiencing an overdose on the premises of a Part 2 covered program, and law enforcement arrives and they have Narcan. They are not typically considered to be medical personnel, but Part 2 doesn't have a definition of medical personnel. This exception focuses more on a person that needs the information to immediately treat a condition posing a threat to the person that requires immediate medical intervention. In my opinion, a law enforcement officer with Narcan would meet that definition, and a disclosure could be made that the person is overdosing and is in need of Narcan. that's something that a Part 2 program would have to consider and would have to capture in their program policies if they are going to go ahead and make disclosures to law enforcement for those very narrow purposes. But that question was brought up to me a while back at a training, and I think that it is something that could apply in terms of making disclosures under this exception. So something to consider. Just like HIPAA and all of the confidentiality laws, reports of suspected child abuse or neglect can be made to appropriate state and local authorities. And frankly, Part 2 starts off by saying it doesn't apply to this information, so it's not technically even an exception to the Part 2 confidentiality requirements. It's excluded from even being protected to begin with. What's important to keep in mind here is that Part 2 only permits the initial report to be made and only disclosure of information that's necessary to get that report into the appropriate authorities' hands. Part 2 does not allow follow-up investigations or provision of information or testimony or what have you of protected Part 2 information under this disclosure. It's simply the report to get it to the right person. Part 2 also permits disclosures pursuant to a court order, but what is very interesting about Part 2 is your run-of-the-mill court order is not sufficient to authorize the disclosure of Part 2 protected information. So for the HIPAA protected information, if a court order is issued authorizing disclosure, that works under HIPAA. It's got that required by law and judicial proceeding exception. Under Part 2, the run-of-the-mill court order would not be sufficient. Part 2 has a very lengthy section of the regulations that talk about what a Part 2 compliant court order is. The court must follow specific requirements in issuing the court order, and the intent of the court order is to authorize the program to make a disclosure even though the information is protected by Part 2. Keep in mind that a subpoena alone does not authorize the program to make the disclosure of Part 2 protected information. A court order authorizes the disclosure. If it's accompanied by a subpoena, the subpoena then compels that disclosure, but a subpoena alone is not sufficient. So this is something that's especially important to point out when we're looking at exchanging information with the criminal justice system, between the behavioral health and criminal justice system, because frankly, most courts, most judges do not know there is a lesser known federal confidentiality law that requires them to follow very specific requirements in issuing a court order for the disclosure of this information. So this is something that's important for those in the criminal justice system to understand, and it's also important for those that are Part 2 protected providers to communicate to their partners at the courts that although a court may think issuing a standard court order is sufficient for the disclosure of information, if that information includes substance use disorder identifying information about a person, it's got to comply with these additional requirements contained in Part 2. So something to note here. Unlike HIPAA, where we had all those different disclosures that could be made of HIPAA protected information, note what are not Part 2 related exceptions. There's no required by law exception, such as I mentioned earlier, the felony reporting law. Ohio has that felony reporting law, and because information's required to be disclosed in that regard under Ohio law, HIPAA permits the disclosure. But Part 2 does not have a required by law exception, and because it's federal law, it trumps Ohio's felony reporting law. So if Part 2 protected information would be revealed in complying with the felony reporting law. It cannot be disclosed under Part 2. That's where it becomes very important, as I kept mentioning earlier on in the presentation, that if you can remove Part 2 identifying information, then that information is only protected by HIPAA and can be disclosed under one of HIPAA's more reasonable and broader permitted disclosures. So say, for example, the felony reporting law applied. A person needed to, or was required under Ohio's felony reporting law to make a disclosure, but in making that disclosure, Part 2 information would be revealed. If somehow that report can be made without the person being identified as a substance use disorder recipient, that information is no longer protected by Part 2, and HIPAA, which would still apply, allows that disclosure to be made under its required by law provision. So just keep in mind that Part 2 is much more narrow in terms of disclosures. So whenever that Part 2 identifying information that specifically identifies the person as a substance use disorder recipient can be removed, it opens up the disclosures that can be made. Likewise, just like there's no required by law exception, there are no disclosures that are permitted to be made in response to an arrest or a search warrant, a subpoena, or a standard court order under Part 2. And there are no correctional institution, no jail-related exceptions, as we talked about under HIPAA. So a much more stringent law in terms of protection of Part 2 specific information. And whereas under HIPAA, I talked about redisclosures of HIPAA protected information being permitted to be made as long as the person redisclosing the information isn't also a HIPAA covered entity or contractually bound to protect the information. Part 2 continues to protect the information on down the line. I talked about the lawful holder concept. So technically, if a Part 2 program discloses Part 2 protected information to a court, for example, pursuant to the person's authorization even, the court becomes a lawful holder of that Part 2 information, and under Part 2, they would be prohibited from redisclosing that information. Keep in mind, as I talked about earlier, Part 2's protections are intended to be provided on down the line wherever that information goes. The protections follow the information. So to make a redisclosure, either a new authorization from the person has to be obtained, or if there's a permitted exception under Part 2, the disclosure can be made. So it's important, and we'll talk about this more when we get more specific about disclosures to the criminal justice system. It's important to think about how authorization forms are drafted, because if you know that a person's authorization is needed to disclose information to a jail, that information may very well also need to be disclosed to the court. So that same authorization form can allow redisclosure from the jail to the court, or from a mental health provider, for example, to a court. So you have to be thoughtful in terms of thinking how that information is going to flow, how it's protected and how it's restricted, and how processes and documents should be drafted accordingly to allow that information to be disclosed when you know that it's going to need to be shared with other organizations and entities. A few additional Part 2 specific requirements I wanted to talk about is Part 2 very specifically states that even if an entity lawfully obtains Part 2 protected information, so say for example, a disclosure is made to a law enforcement officer of Part 2 information, that information is prohibited from being used to initiate or substantiate criminal charges against a person or to conduct an investigation of that person. The only exceptions to that are the crimes on premises or against program staff, or pursuant to a very specific court order issued for this purpose. The Part 2 compliant court order gets even more strict in terms of requirements if that information is going to be used against the person. And the point of this strict prohibition is because Part 2 was originally drafted in order to make persons feel comfortable in seeking and receiving needed addiction services, being confident that their information is not going to be used against them or disclosed to employers or disclosed to the community or what have you. So the regulations itself are specifically intending that if a disclosure of that Part 2 information is made, it can only be used against the person in a criminal manner in those very narrow situations. Rather similarly, Part 2 is very specific in terms of undercover agents and informants being in substance use disorder programs. So you may have a residential treatment program and an undercover agent or an informant would enroll in the program in order to determine criminal activity of the program or of those enrolled in the program. Part 2 says that in that regard, that a Part 2 program may only employ or enroll those persons if there is a court order authorizing them to be part of the program. And it goes on to state that the court can only issue an order in that regard to investigate suspected criminal conduct by staff or agents of the program. And that information cannot be used to prosecute the person. So again, this is making a person feel comfortable and confident that if they seek needed treatment, it's not going to come back on them, the treatment piece of it's not going to come back on them in some punitive capacity. So they should be secure if they're in a residential treatment facility that they can share and disclose and do whatever in that program without it potentially being used against them in a criminal proceeding or investigation. Part 2 also talks about specific requirements in terms of acknowledging the presence of a person in a facility. So, often I hear from Part 2 programs that that law enforcement might show up at the door of the program and ask if a specific person is present at the facility. Part 2 very specifically states that that information can only be disclosed if it does not identify the person as being a recipient of substance use disorder services. So if it is a addiction services only facility, the response would have to be they cannot confirm nor deny that the person is present at the facility, just because by virtue of that person being present at the facility as a client, it would be disclosing they are a recipient of substance use disorder services. So the only way that disclosure can be made is perhaps if it's part of a larger facility. The Part 2 program might also be part of a larger healthcare organization where there are physical health services or mental health services provided, where as long as they're not sharing verbally information about the person being a Part 2 recipient, just by virtue of that person being present, does not disclose that they are a recipient of substance use disorder services. And the same goes for a request for disclosure of client records. Responding to a request for disclosure must be made in a way that does not confirm that a person has been or is receiving services there. So again, it might be under Part 2, we cannot confirm nor deny whether we have a person's records because we are a substance use disorder program or something to that effect. And the program can go ahead and provide the requester with a copy of the regulations or information about the regulations so they understand what they need to obtain in order to have information disclosed to them about a client of that program. So that was permitted disclosures and what's not permitted under 42 CFR Part 2. I wanted to very briefly talk about the permitted disclosures under the Ohio MOS statute in terms of the criminal justice system. And we'll just mention these briefly and you'll see why. The Ohio MOS statute, in addition to disclosures that can be made of addiction records in Ohio's behavioral health system, it's the same disclosures as 42 CFR Part 2. And that's because 42 CFR Part 2 trumps all other laws that authorize or permit disclosure. If it's not permitted to be made under 42 CFR Part 2, it does not matter if it's authorized by another law. So essentially, Ohio's statute in regards to addiction records mirrors 42 CFR Part 2 as far as disclosures that can be made. The mental health confidentiality statute, it has a laundry list of permitted disclosures, but it has a catch-all category that says it permits disclosures authorized by other state and federal laws. So that law is essentially saying, or that statute's essentially saying that if it's permitted by HIPAA, it's also permitted by the Ohio MOS statute. Or if something in state law, such as the felony reporting law, that wouldn't be a good example. Let's say, for example, the child abuse reporting statute under Ohio law, because a disclosure is authorized under that law, it's also permitted under the OMOS statute. It does go on to provide for some additional disclosures that are specific to Ohio's behavioral health system. So where it talks about disclosures for treatment and payment purposes, just like HIPAA, and then it has that catch-all category that pretty much says permitted by HIPAA or other law, means it's permitted by the Ohio MOS statute. It also has some Ohio behavioral health system specific things, and the one that I wanted to point out in that regard relates to involuntary commitment proceedings. And what it says is that records of a person's diagnosis, their treatment, their prognosis is required to be made to a prosecuting attorney if the person is committed under one of the criminal statutes, or to an Adam Board designated attorney for other civil commitment proceedings. So whereas, of course, because this is specific to Ohio's involuntary commitment proceedings, you wouldn't find something quite on point as this one in HIPAA. But because HIPAA says disclosures that are required by law, state or federal law can be made under HIPAA, and this one in OMOS's statute requires disclosure, it's also okay to be made under HIPAA. So final note on permitted disclosures is when both HIPAA and Part 2 apply to a disclosure. When that occurs, and that would occur for most Part 2 programs, most substance use disorder treatment programs are going to be a Part 2 covered program and a HIPAA covered provider. And when that is the case, they must comply with the law that is the most protective of the information in regard to that disclosure. And keep in mind, as you have seen, that 42 CFR Part 2 will always be more protective than HIPAA when it comes to information that identifies a person as a substance use disorder treatment provider. So if both HIPAA and Part 2 apply to the information, and HIPAA permits the disclosure to be made without authorization, but Part 2 does not, that authorization still must be obtained because you have to comply with the one that's more protective. An easy example of that is HIPAA permits disclosures to be made for payment purposes without authorization. Part 2 does not have a payment purposes permitted disclosure. So as a result, a substance use disorder treatment program must comply with Part 2 since it's more protective and obtain a person's authorization prior to making a disclosure for payment purposes. And again, Part 2 is almost always going to be the more protective law when it comes to Part 2 protected information being involved in the disclosure. All right, so we looked at the disclosures that can be made that are pertinent to the criminal justice system and that can be made under each of these laws. I want to look more at specific requirements and recommendations for the sharing of information between behavioral health providers, courts, and jails. So we have a better understanding of when disclosures can be made. Now let's look at more the practical side and how some of these things specifically apply to those organizations and persons within the criminal justice system. So in starting off talking about sharing between systems, I wanted to make it clear that in general, those in the criminal justice system are not typically covered by HIPAA and Part 2, as I've mentioned throughout. So they can go ahead and disclose information about a person that they obtained personally or from third parties to behavioral health providers. So when we were talking about disclosures under HIPAA and disclosures under Part 2, those were disclosures that are going from behavioral health providers to the criminal justice system. Keep in mind, as we're contemplating how to make the sharing of information work, usually those in the criminal justice system can make a disclosure without those confidentiality laws applying to behavioral health providers. So again, you know, if a mental health court does an assessment and identifies somebody is in need of mental health services, that court is not a HIPAA covered provider, and they can go ahead and disclose to a mental health provider that a person is in need of services or has been assessed and the assessment indicates the need for services. And then keep in mind also what I said about disclosures, redisclosures of information. So when it comes to HIPAA and mental health information, protected health information received from a mental health provider can be redisclosed. So if a mental health provider under one of those law enforcement exceptions discloses information to a police officer, that police officer can go ahead and further disclose that information. Same with court personnel, what have you. That the bottom line is that HIPAA typically does not prevent redisclosure of information. I do need to point out on the flip side of that, that Part 2 protected information typically cannot be redisclosed. So you always have to keep in mind when you're talking about a mental health client or a substance use disorder client, that there are these different rules here. And in general, mental health, when it's necessary information, there are the more common sense disclosures that can be made, whereas Part 2, for the most part, is going to be locked down, and one option is to receive or to obtain the authorization of the person to disclose their information, or to try to strip out that substance use disorder specific information and disclose what's permitted to be disclosed under HIPAA without identifying the person as an SUD recipient. So the first area of the criminal justice system we'll look at is jails. And I had mentioned early on that not all jails have HIPAA covered staff in them. So to determine whether the jail or the jail staff is HIPAA covered, the first thing to look at is if the healthcare staff if they have healthcare staff, I should say, their own staff internally, and if they do have healthcare staff or contractors, are they transmitting electronic transactions? As I talked about early on, it's not all healthcare providers that are covered by HIPAA. It's healthcare providers that transmit certain health-related information electronically. If that is the case, then the jail staff is HIPAA covered. It is possible for jails to set themselves up as a hybrid entity where only the healthcare units are HIPAA covered, because of course you don't want an entire jail to be considered to be a HIPAA covered entity, because then that restrains what the jail can do in terms of its normal functioning. So essentially segregating between the jail administrative staff and the COs and what any jail healthcare staff or healthcare contractors hold would be required. If healthcare providers are purely external or community-based, so if the jail has healthcare providers coming in to work with inmates, but they are community-based providers and not part of the jail workforce, then the jail healthcare staff is not covered. So let's say, for example, that there are mental health providers coming in from the community to provide mental health services. They're not part of the jail workforce, so the jail does not become HIPAA covered by virtue of them being there. So the jail may have a doctor or a nurse on staff, but they're not billing for services electronically. They're not conducting any electronic health transactions, so that doctor and nurse on staff are not HIPAA covered, and just by virtue of those community-based mental health providers coming in, the information maintained at the jail does not become HIPAA covered either. It would be those external providers that would most likely be HIPAA covered. When it comes to the exchange of information between those HIPAA-covered providers, keep in mind that if the jail does have a contract mental health provider that is solely not a community-based mental health provider, but solely a jail psychiatrist that works with persons, with inmates at the jail, they can exchange information with those community-based mental health providers and physical health providers, what have you, because as we talked about early on, that exchange would be for treatment purposes. And it doesn't matter if the providers are HIPAA covered or not, healthcare providers can exchange protected health information with one another for treatment purposes. So talking about ongoing treatment needs of the person, medications, providing information at the time of release for continuity of care purposes, the in-house healthcare staff that may or may not be HIPAA covered can exchange that information back and forth with the community mental health provider as needed to ensure that person's treatment needs and treatment planning when it comes to discharge are going to be met. So now let's talk about disclosures by HIPAA-covered community providers, including those jail contracted providers, to jail staff. As we talked about earlier, if you are a HIPAA-covered provider, you can go ahead and disclose information to jails for certain purposes, providing health care to inmates, such as medication information. If it's necessary for the health or safety of the person, let's say, for example, they're suicidal, or the health or safety of others, they're threatening harm to others. For the administration and maintenance of the facility, that rather broad category I talked about earlier and gave some of these examples of. And again, to jail healthcare providers for treatment purposes. Those are the purposes for which your HIPAA-covered community providers can disclose information to jail staff, whether or not the jail staff is a healthcare provider or not. And then the only other way to disclose information to jail administrators or jail staff would be with the person's authorization. So if it doesn't fit within one of those categories, and I think in most cases it would, any disclosures that are needed to be made to the jail, because they are rather common and common sense oriented and broad. But if there is not one of these categories that apply, the person's authorization would need to be obtained to make disclosures to jail staff. And then keep in mind that information that a jail administrator, and by jail administrator I mean a non-healthcare person at the jail, disclosures that they can make of information they obtain from healthcare providers or mental health care providers is not subject to HIPAA, so it can be redisclosed. So say for example, a community mental health provider under this last exception we talked about discloses information to the jail, information that is necessary for the health and safety of the person while they're in the custody of the jail. That jail administrator can then go ahead and redisclose that HIPAA protected information to the court, for example, notify the court of persons booked that have a mental illness or on psychiatric medication, so that the court can go ahead and determine if diversion or early resolution of cases or special dockets or whatever is available. So one thing to keep in mind is, as we talk about disclosures of information from the behavioral health system to the criminal justice system, the flow of the information matters. So getting this understanding that this training provides today and then putting it into practice is going to be important in order to make needed disclosures. So for example, whereas a community mental health provider, as we'll see here in a little bit, usually cannot disclose information directly to the court in terms of who's been booked into jail and has a mental illness, HIPAA permits that disclosure to be made to the jail, and then the jail can go ahead and disclose information to the court. So it's something to think through in terms of common disclosures that you make and you need to make and how they can be made in compliance with these laws. 42 CFR Part 2 is very different than HIPAA as usual in regards to disclosures to jails from a Part 2 program. The person's authorization is needed, a Part 2 compliant court order, or again, under that medical personnel exception, if there's some immediate threat requiring immediate medical intervention. But when it comes to specialized dockets, bail decisions, release conditions, pretrial services, a Part 2 program would need the person's authorization in most cases in order to disclose information to the jail, and as we'll see here in a little bit, to the court as well. The next area of the criminal justice system that I wanted to talk about is law enforcement, and we already covered the permissible disclosures to law enforcement. So in this section, I wanted to talk a little bit more about the options and recommendations for when disclosures are not permitted under HIPAA or under Part 2. So keep in mind that when HIPAA or Part 2 do not permit disclosure to law enforcement, a provider can always provide general information to law enforcement. Law enforcement doesn't always need to obtain client-specific information from the mental health provider. So law enforcement can call a community mental health provider with a concern about somebody they're interacting with. And the provider can go ahead and offer general advice without ever sharing whether that person is a recipient of services or you know, if they have a mental health diagnosis or what have you. Sometimes law enforcement just needs that professional advice from the behavioral health system for interacting with a person experiencing substance use issues in an emergency situation, for example, like with a person overdosing. They don't need to know the name of the person or, you know, anything else about the person. They just need to know how to deal with that situation. Same in a mental health situation. If professional advice could be beneficial to law enforcement in a non-emergency situation, simply, you know, just how to de-escalate or how to hook the person up, connect them with services. Those things can be disclosed by a provider without disclosing protected information. And they can share general knowledge or information about a person from the community. If that provider has never received services, there's nothing that is protected about them. So the provider can share, you know, especially in a smaller rural community, that, you know, John Doe is known to have an opiate habit, and, you know, the provider can talk about how law enforcement can go ahead and link that person up. So if they're not a recipient of services already, the local mental health provider, substance use disorder provider can be contacted and can share that general knowledge they know about the person that would help get them connected to services if they haven't already been in regard to that particular provider. Another thing to keep in mind with law enforcement is if one of the permitted disclosures doesn't apply to information that law enforcement needs about a person or thinks it would be beneficial to have about a person, law enforcement themselves can go ahead and obtain the client's authorization for the provider to disclose information to law enforcement. A provider cannot require a person to sign an authorization. But if law enforcement, for example, is typically engaging with the same person over and over, one of those high utilizers that they keep seeing come back and forth, and law enforcement feels that it would be beneficial to be able to talk with the person's treatment provider about what's going on with that person, or for having the treatment provider be able to communicate certain status changes about the person to law enforcement, then law enforcement can go ahead and seek to have the person sign a authorization form that they then give to the provider, and that authorizes the provider to make disclosures. And law enforcement can explain to the person that this is for their safety, that the law enforcement, you know, especially CIT officers, want to be able to work with that person's provider to keep them as safe as possible. And the person may very well think that that would be beneficial to them as well and go ahead and sign that authorization. And I will mention, I don't know if I have it on a slide in here, but Ohio now has a standard authorization form. It's part of statute and the related rule, a form that anyone can use for a person to authorize disclosure of their information. So I'm sure those in the criminal justice system are very well aware that providers are very particular about what's included on a release of information or authorization for disclosure of information. And that's because the confidentiality laws are very specific about what's included on an authorization form. Well, because of Ohio's standard authorization form, there is no need for law enforcement or courts or jails to go out and try to figure out how to draft up an authorization form that would comply with those laws, or to seek one from a provider. If law enforcement or courts or whomever, any person, even a family member, obtains a person's authorization on Ohio's standard authorization form, the healthcare provider is required under this rather new law to accept that authorization as valid and to go ahead and make the disclosure accordingly. And I have a link on the resources slide at the end to where those standard authorization forms can be found. Some additional Part 2 related law enforcement recommendations. When a behavioral health provider is working regularly with local law enforcement, it's important that the Part 2 program, the SUD providers, communicate with law enforcement that Part 2 goes even beyond HIPAA. So whereas in many instances that common sense information can be made, those disclosures can be made from the mental health provider to law enforcement. Law enforcement should be aware that there is an additional twist in the behavioral health system when it comes to persons receiving substance use disorder services. Again, on the second bullet point, keep in mind that if you can remove the SUD specific piece, disclosures can be made under HIPAA's law enforcement exceptions. So it might be that you are helping law enforcement track somebody down that just committed a crime, and there would be no need to include substance use disorder specific information. So if you are a larger healthcare provider, you provide mental health and substance use disorder, or there's physical health services, and you're not just by virtue of the type of organization you are disclosing they're a substance use disorder recipient, pull out that substance use disorder information and disclose it as you're allowed to under HIPAA. Also keep in mind disclosures can be made anonymously if you can't strip out the Part 2 protected information. Information can be provided anonymously by Part 2 providers if it's information law enforcement needs to receive. And then also keep in mind what I mentioned about medical emergencies, and does that exception apply when a law enforcement officer has that life-saving Narcan that's immediately needed to save the life of a person. I think that is something worth pursuing further within Part 2 programs with your legal counsel and seeing if that's something that would be recommended for policies and procedures of the program. So the last area of the criminal justice system that I wanted to provide some additional information about is courts. It's the courts and information sharing between courts and behavioral health providers. So for mental health providers, sharing information to courts for court proceedings in general, there is no specific exception that applies. So giving information to prosecutors, defenders, the court, the parole board, those disclosures can only be made by mental health providers with the person's authorization, when it's required by law or pursuant to a court order, if it could prevent or lessen a serious and imminent threat to health or safety of others. Remember, under that exception, if the person is reasonably likely to be able to reduce or lessen the threat, prevent the threat, what have you, disclosure can be made to that person. And in some case, that could be the court that is reasonably likely to prevent or lessen a risk of harm to the person themselves or to others. And then also keep in mind with court and court proceedings that what's in a court journal entry and court docket entries is not protected information. So even if mental health information ends up getting in there, that is not protected information, and that can be that court journal entry or court docket entry can be forwarded to those that need that information. There's also no exception for disclosures by mental health providers to mental health courts or for court-ordered treatment purposes. Often, because it is a specialized docket, a specialized division of the court, persons think that treatment providers can go ahead and make disclosures to the court about the status of the person's treatment, but there is no permissible disclosure, as we have seen, that would allow that disclosure to be made. So a court, my recommendation is that a court require authorization as a condition of participation when a person is being considered for court-ordered treatment or mental health court. The court is able to require that that person, as a condition of participation, authorize disclosure by their treatment provider to the court as needed for the court to determine eligibility for the specialized docket program, for diversion, what have you. And then also keep in mind that a probation officer can disclose information to the court. I talked about the flow of information and how that's important. So if a treatment provider doesn't have authorization to disclose information directly to the court, oftentimes, because it's required under state law that a provider report certain things to probation officers, that probation officer is not a HIPAA covered entity, and they can go ahead and redisclose that information to the court as needed. Very briefly, I will mention forensic monitoring. Forensic monitoring is something that is required under state law to occur, and it specifically states that tracking updates must be made to the court and to the court coordinator. So keep in mind when it comes to those tracking updates, they can go ahead and be made to the court without the person's authorization because it is a specific program authorized under Ohio law. Part 2 disclosures, Part 2 covered providers can only disclose information to those prosecutors, defenders, court, parole board, etc., with the person's authorization, with that Part 2 compliant court order, or if the information is contained in court journal entries and court docket entries, that's not protected. But pretty much the same as HIPAA in that regard, that when it comes to just general court proceedings without there being some subpoena or order or authorization, that information can't be disclosed to the court. What is helpful is when it comes to court-ordered substance use disorder treatment and drug courts, there is a specific set of requirements in Part 2 in terms of the authorization to disclose information to the court. So even though the person's authorization is still needed for those SUD treatment providers to disclose information to the court, Part 2 has recognized that some of the provisions contained in the authorization form wouldn't work very well for those purposes. So it talks about, I think I'm on the wrong slide, I'll come back to that one. It talks about the authorization requirements being more flexible in regards to those persons receiving certain court-ordered SUD treatment. Redisclosure is permitted in those instances. So if a disclosure is made to the court under the authorization, the official at the court can go ahead and redisclose information as needed, perhaps to a probation officer or whomever under that authorization form. And the person cannot revoke the authorization at will either. Typically all disclosures, releases of information can be revoked by the person at any time, but when it comes to court-ordered substance use disorder treatment, there is allowed to be a statement on the form that they cannot revoke that authorization for disclosure of information to the court until final disposition of the proceedings or the person is released from whatever type of control that they are under in regards to the court. go back to that one that I was just on. So when we're talking about disclosures to a drug court or a court-ordered substance use disorder treatment program, you do need that either a Part 2 compliant court order, the authorization that is required under the OMA statute, and even beyond the OMA statute requiring authorization as condition of participation in an SUD treatment program, it's recommended that the court, as a matter of course, go ahead and require authorization as a condition of participation so they can be sure they can get the information they need about that person's treatment and status updates in order to make their determinations. And then going back to what I had just talked about, there are those special Part 2 authorization requirements when it comes to that court-ordered treatment. We're getting really short on time, so I will very briefly recommend and mention some things, additional things to consider. I've said this first one a couple times. Mental health and addiction providers can always share general information about how to best handle an interaction with someone that's experiencing a mental health or substance use issue in a court or jail, or law enforcement is reaching out for information. There's also that redisclosure that I talked about, and the recommendation that those in the behavioral health and criminal justice system look at the flow of necessary disclosures so processes can be adjusted to allow for the sharing of necessary information. For example, where I talked about a provider might not be able to disclose information directly to the court, there are disclosures they can be made to the jail that the jail can then further disclose to the court. Keep in mind what I said about written authorization being able to be obtained by anyone, that it can be obtained by court staff, jail staff. It doesn't always have to be the provider obtaining that authorization. And the client should be educated, especially inmates, that it's in their best interest to allow those disclosures, that the intent is to help them and assist them and support them by being able to share that information. A multi-party authorization listing all parties that need to exchange information can be utilized. And as I mentioned, Ohio now has a standard authorization form for sharing of information. It's only between 2 parties, but what's really beneficial about it is the information is required to be disclosed. It contains all of the elements it needs to contain, so a person that's not in the behavioral health system can simply go to the specific area of state law, pull down that form. If the person authorizes disclosure, that form can be provided to a mental health or behavioral or substance use disorder provider, and they have to go ahead and disclose the information specified on the form. Some resources for you. I hope that this presentation itself is a resource for you. I purposely include a lot of detail on slides so that you can go back at a later time and use it as a reference document. But I wanted to provide you with a link to the statutes and regulations, rules that I talked about specifically, so you can go there for more information. And I also wanted to give you links to Ohio's standard authorization form, which I've talked about a couple times now. I give you the code sections there. And also these forms can be found on the Ohio Department of Medicaid's website. So I gave you the link to the forms and to the instruction to the forms. And then lastly, I wanted to make you aware that there is a series of manuals that I have drafted for the Northeastern Ohio Medical University Criminal Justice Coordinating Center of Excellence. There's a manual series titled The Sharing of Confidential Mental Health and Addiction Information in Ohio, and it's specific to sharing of information with the criminal justice system. So the first manual was more specific to law enforcement. The second manual was more specific to jails and courts, that should say in courts. And there will be other manuals coming out as well. So I provided you links to those manuals, which frankly go into a lot more detail, provide FAQs, additional forms and resources, checklists that you can use. So that's it for today's presentation. I hope you found it to be helpful and informative. Thank you and have a good day.